for those of you who are unfamiliar, the entire global system of government and economics all operate in the system of commerce. Today we won't actually go over any specific procedures. Today is basically just foundational so that you get an idea of how things are working. Once you have an idea of how things are working, we'll actually move forward with actual procedures that we use as creditors. We will distinguish between operating as a debtor and operating as a creditor. However, I'm sure none of you need any education on operating as debtors, seeing as you're educated by the public school systems to be debtors from the time you're very young. So we won't be touching too much on debtors other than to make the distinction between how a creditor and a debtor differ in their actions within commerce. So to start off, maybe I'll go through what I call law forms and jurisdictions. Law forms, we can look at it like a pyramid. Each successive law form falls within the law form before it. And at the top of the pyramid, we have natural law. Natural law is that law form that makes it possible for you to be here. Your existence, creation itself, the physics of the universe, all come under natural law. Okay? Underneath natural law, the next law form would be commercial law. Commercial law is any interactions between sovereign beings. When I say sovereign, all I mean is someone who has control over their property. Not someone who is in possession of property, not someone who is an owner, but someone who actually controls. Okay? Two sovereign entities have complete freedom to contract with each other in any way that they see fit. There are no oversight of their contract. If two individuals outside of any jurisdictions decide to contract between each other, that would be in the area of commercial law. The next level down I would call common law. Common law is a society or a group's agreement on how to interact with each other. For instance, you have the United States. And the United States is a society. And within this society, we have decided that there are certain guidelines under which we will conduct business with each other, and we are in agreement under those guidelines. So that's what I would call the common law. Now, within the common law, I don't mean it in the sense, if you've heard of law forms such as admiralty and commerce and statutes, I'm not talking about it in that sense. When I say common law, I'm just meaning, in general, a group of people have decided to be under these guidelines. Okay? The next level would be what I call statutes. Now, statutory law is, for example, the U.S. has 52 titles of statutes in the U.S. Code. For instance, I'm sure you've all heard of the tax code. And the tax code is Title 26 of the U.S. Code. That falls into the arena or the law form of statutory law. Underneath statutory law, is it 1, 2, 3, 4? Yeah. We have the final law form, or the lowest on the pyramid, and I would call that political law. The basic law forms that we will be discussing today most of us operate in statutory law. If you operate as a U.S. citizen or as a U.S. corporation or as an officer of a U.S. corporation, you're operating within statutory law. Now, the advantages of understanding how to be a creditor in commerce is that you will learn how to operate in the highest law form, which is commercial law. And you will learn to do that through being as a creditor, you will learn to control property. Okay? Does anyone remember the quote by Rockefeller back in the early, I believe it was the 1800s, early 1900s? It was early 1900s and the antitrust things were going on. He said something to the effect of, and I'm paraphrasing, own nothing, control everything. Has anybody ever heard that quote? Okay. Do you own your car?
No, I do.
Well, let's say your car's paid for. Do you own the car?
No.
You do own the car. Okay? You do not control the car. Can the state take the car away from you? Yes, because they control it. Okay? Now, there are two different types of title. There is equitable title and there is legal title. Okay? Equitable title is owner, operator, debtor's title. Okay? When we say you own your car, that's what we mean. You have equitable title, meaning you can sell it and you can make money from selling it, but you do not have control over the vehicle because you did not issue the title for the vehicle. The state issued the title and they gave you a certificate of title. Okay? That means they're holding the legal title. The legal title to the car was actually the MSO that came from the dealership when you purchased the car. The MSO got sent to DMV or the state to hold. They are holding the legal title.
What it stands for, MSO?
MSO, Manufacturer's Statement of Origin. Yeah. So that's the actual title on the vehicle. Okay?
Do they ever disclose that when they sell you the car and you just don't know where?
No. Actually, you do sign something that gives them a power of attorney to send it to the state. Okay? Your documents that you sign in closing on the vehicle, you basically give them power of attorney to take the MSO and give it to the state on your behalf. Now, if you were purchasing the car and you told them, I'm taking this to a foreign jurisdiction, I am not keeping it here in the state, they'll give you the MSO if you ask for it. Okay? But again, that's a procedure, and we need to talk about being a creditor. I wouldn't suggest to anybody in here that you go and take legal title of your vehicle, because being a creditor involves a lot of responsibility. Okay? The person with legal title takes responsibility for the property. Now, these are not official titles of actual jurisdictions. So, what I'm talking about when I'm discussing jurisdiction A and jurisdiction B, jurisdiction A I will also refer to as private. Jurisdiction B I will refer to as public. Okay? I'll also refer to jurisdiction B as a democracy. And I will refer to jurisdiction A as a republic. Let's see, how else do I break down jurisdictions? That's good for now. So, how many of you are familiar or know the difference between a republic and a democracy? Okay, a couple people. When the United States was established in 1776, not 1789, with the Declaration of Independence, we established, through the Articles of Confederation, a republic. A republic is sovereign. It controls its property. Okay? In 1782, with the end of the Revolutionary War, the national government went to the people, or the states, I should say, and asked the states to foot the bill for the debt that had been incurred by the national government. With the creation of the national government in 1776, or the signing of the Articles of Confederation, the national government took on the debt of the Revolutionary War on behalf of the states. Okay? The states in 1782 basically said they would not pay the debt. Okay? So the national government was forced to form a constitution. Okay? Does anyone know what a constitution is? Okay. Does anyone know the definition of a constitutor? One who creates a constitution. Definition of a constitutor is basically one who passes his debts to a third party. Okay? If you read the Constitution, pay very close attention to the preamble in Article 6, you'll notice that they capitalize a lot of words that really, by the proper use of English, shouldn't be capitalized. Right there in the preamble, it says something about securing the
Blessings of liberty.
securing the blessings of liberty, and it's capital B, capital L. Okay. The Constitution itself is a security. Because the states wouldn't pay the debt, they had to create a security with sureties to basically back the debt, so that the national government could do business with other national governments. Basically, if you don't pay your debts and don't have a surety for your debts, no one's going to do business with you. Like when little Timmy, 16-year-old Timmy wants to go buy a car, is the dealership going to give Timmy, approve his credit to be on that vehicle by himself? No, he needs a surety, a cosigner. Okay? So the states signed on the Constitution as sureties, saying, yes, we will back the debt of the United States. Okay? So in 1789, with the signing and the completion of the Bill of Rights and the Constitution, you had a security instrument for which the debt of the United States was now attached to. Okay? That debt, we basically went into what's known as an international bankruptcy at that point. Since we didn't pay the debt, the national government went to the UK, the King of England, and said, will you buy this debt? The King of England said, sure, we'll back your debt, we'll pay your creditors. And in exchange, they took legal title over the national government's property. Okay, so since 1789, you've basically, in 1789, the national government lost its sovereignty. So we were a republic for 7 years, 1782 to 1789. So the term for an international bankruptcy is 70 years. Okay, so 70 years after 1789, we get into the year 1859. Does anyone know what happened in 1859?
Civil War.
Civil War. Okay, the reason for the Civil War, the real reason. Okay, slavery was already on its way out. For those of you who know international treaty and what was going on around the world at the time, it had already been outlawed internationally. So basically, America was in the process of following suit. But it was at the end of the bankruptcy, the debt is due. Okay, and the states signed on as sureties on the Constitution saying they would pay the debt. Okay, so King of England, through his bankers and Rothschild's Bank of France, basically said, okay, debt's due. You states said you'd be surety. We want our money. And the southern states, or the northern states went to the southern states and said, basically, you guys have all the money, you have all the gold, you have all the cotton, you have all the resources, you have all the wealth. The material wealth of our nation was pretty much wrapped up in the South. And the South said, yeah, no, we're not going to pay the debt. We're going to start our own country. And because of their dishonor with the international bankers, it was now up to the North through, or up, it was the will of the creditors to get the debt paid or to take sureties for the debt. So basically, we fight a war, end of the war. What gets resolved is now the states have lost their sovereignty because the states refusing to pay their debt to the creditors started another 70-year process, another bankruptcy. Okay, we didn't pay our old bankruptcy, so now we're going into another bankruptcy, except this time they're going to take away something else. The first bankruptcy, they took away the nation's sovereignty. They took that away because of how? Because the national government no longer could control its property. Whoever holds legal title controls the property. Okay, but now the states were in dishonor. So the international creditors were now taking control of the state's property. Okay? So the states no longer have their sovereignty because they don't control their property. That's the only thing that distinguishes a sovereign from someone who is not a sovereign. If you're a debtor, you're not sovereign. Creditor controls. Okay, remember we had the Constitution in 1789. Right. And in 1791, Alexander Hamilton created the Bank of the United States. Bank of the United States is where the securities were being held. So basically the international creditors wanting a guarantee of payment said, okay, you hold your securities in this Bank of the United States and we're all good. Okay? The Bank of the United States had a 20-year charter. So fast forward 20 years, 1811, and Congress decided, no, we're not going to renew the Bank of the United States. We're going to get rid of it. Okay, it wasn't a real popular thing anyways. Again, pissed off the creditors. Creditors basically, at that point, said, no, you don't, and they sent their troops in. So we had British troops on American soil, and they burned the White House and took possession of all the federal courts. Now, why would they take possession of the federal courts? That's where the titles are. They're taking control of the titles. Okay, as long as they control the property, that's all they care about. So after they burned the White House and took control of the property, we decided we'd renew the Bank of the United States, and they left. Okay, so 1859, second bankruptcy, states lose their sovereignty. Fast forward 70 years, 1929. What happened in 1929? Stock market crashed. Okay, what happened in 1929? The debt became due. Actually, let's go back 20 years before that because they were already in preparation. Has anyone ever heard of the Federal Reserve Amendment and the Income Tax Amendment and Jekyll Island? Okay. In Jekyll Island, the international bankers, along with the Secretary of Treasury, got together in 1909 and said, okay, how are we going to handle this? In 20 years, this debt is due, and we don't have the money to pay it. So, what are we going to do? And they came up with the Federal Reserve System. Okay? And the Federal Reserve System and the tax collectors. Does anyone know like the stories of, let me think, actually, let's go back to the Bible. In the Bible, who were the tax collectors for Rome? Were they the Romans? Or were they the people of the territory that they had taken control of? The people of the territories, right. Now, so the tax collectors, even though they're working for a foreign power, they are your people. You don't send in foreign tax collectors, okay? So the IRS, even though it's made up of U.S. citizens, is working for a foreign power, okay? What do taxes go to? What does your income tax pay?
Interest on the
Interest.
debt, interest on the national debt?
Does it pay for the operations of government?
No.
No, it does not pay for the operations of government. It's going to the creditors. Creditors get the tax. Okay? So 1929 rolls around and bankruptcy's due and we don't pay. We go into another dishonor. This time,
How much money are we talking about? I mean, like I said, look, your monthly payment is $755 billion.
the first, I believe the first bankruptcy, 1789, it was around 13 million. Back then, which probably was a lot more than 13 million now.
Like,
The creditors got their payment. The creditors for the Revolutionary War got paid by the Rothschild Bank of France, okay, Bank of Paris. So Rothschild paid the creditors, but now Rothschild had a security interest in the national government, okay? Okay, so 1929, they had already taken the state's sovereignty. They had already taken the national government's sovereignty. Whose sovereignty did they take in 1929? The people. And how was that demonstrated? Well, Social Security came around in 1933. Confiscation of all the gold and silver and all legal title. Up until 1933, you could hold legal title on your property. It was called alloidial title. If you used gold to purchase your property, the property was yours. You had control over the property. But now, because the people are in dishonor and the people are bankrupt, they no longer control their property. Now, this history that we're going through, I'm not giving this to you to say it's bad or it's good. It's just what is. And it's actually good, believe it or not. I know this infuriates a lot of people to hear that how things actually work, but I'm here to tell you that everything's been set up this way for your benefit, okay? And when you understand how to be a creditor in that system, you'll see how powerful it is. That our old system of law, being in the Republic, being under common law, being under execution of law, is not a good place to be. It's much more destructive, okay?
Can you explain alloidial title, please?
Alloidial title is basically, remember we talked about how title was split into equitable title, legal title? Alloidial title is one and the same. Legal and equitable are no different. It's one title. If you took your grant deed, accepted it for value, and gave it back to the county, you'd be removed from the assessor's parcel numbering system. Your property is no longer on the grid. There's no longer property tax on that property. Now, I'm not saying anybody go and do that because you need to be responsible for the property. That means bonding for sewage, bonding the police department, the fire department, any benefits and privileges that your property receives, you now become responsible for. You were paying the property tax because the state or the county took responsibility for those things. You're not subject to anything except by volunteering and by agreement. Okay? When you lost your sovereignty and your ability to pay your bills, they actually gave you something in exchange. And every time they take something, they have to give you something of equal or greater value, otherwise they're committing a crime. And what they gave you in 1933 was everyone over here in jurisdiction A now has an exemption. You're a creditor, okay? Now, from the perspective of jurisdiction B, you're a debtor. For those of you who are not familiar with trusts, let me give you this sweet and simple. A trust has basically 4 essential parts: a grantor, a trustee, a beneficiary, and res, which is the thing of the trust, okay? Or the property.
Could you say it one more time?
Grantor, trustee, beneficiary, which are the 3 positions in a trust, and the res, or the property of the trust. Corpus is another word for it. Okay. So, we'll call this up here at the top, we'll call this the private trust. And we'll call this trust down here on the bottom, we'll call this the public trust. Okay. So in 1933, they took your title. Not only that, not only did they take title to your land and take away your ability to pay your debts with real money, but they also took title to something else, your body.
Right.
Okay? And that was done through a certificate of title known as a birth certificate. Okay? That birth certificate is the title to your body. Okay? Now you can take legal title of your body back. They were only doing it to give you a benefit. Like you're basically, based on their perspective, you're a bunch of you're a bunch of irresponsible people. That's how they look at it.
You're slaves.
Yeah. So if you want to be irresponsible, we'll let you be irresponsible. But what we're going to do is we're going to put you into this trust here so that we control these irresponsible slaves on the plantation. Okay? So, this is the grantor. This is the trustee. This is the beneficiary. And same down here. Grantor, trustee, beneficiary. Okay. Grantor of the private trust is living men and women. Okay? The trustee of the private trust is a foreign situs trust that is created and evidenced by the birth certificate. We'll get into that in a minute, how the birth certificate works and how it works with titles and everything. So there's a foreign situs trust that was established with your birth certificate. Okay? And when I say foreign, I mean foreign to jurisdiction B, foreign to the democracy. In order for them to create this government on top of a government, they had to first recognize the people over here and say, hey, you're the source of all the energy. You're the source of all the production. So we need to have a legal identity for you in jurisdiction A. Okay? Remember, jurisdiction A is the private or the republic. So that is a legal entity. Okay? And that legal entity we'll call, a lot of people like to call it the straw man. I'll just call it the private trust. Or the, no, that's not good because we're talking about trust here. We'll call it the foreign situs trust. Well, there's two different straw men, so I don't want to call it a straw man yet. Okay, so we'll call it a foreign situs trust. The person? The trustee is a foreign situs trust. Okay. The beneficiaries of the private trust, yes?
I'm not real clear on your definition yet of a foreign situs trust.
A foreign situs trust is an entity that is foreign from jurisdiction B, from the democracy.
So it's just a separation again.
Yes. Okay. It's the legal identity that's on your birth certificate. Typically, the birth certificate will be in upper and lower case for your name.
Oh, okay. So,
Okay, so it's a separate legal identity from the U.S. citizen that gets created. Okay. Beneficiaries of the private trust are the public trust, public entities, the government, U.S. citizens, corporations. Those are the beneficiaries of the private trust. Okay. Down here in the public trust, the grantor is a position that kind of weighs. You're either the grantor or someone steps up to be a grantor. There is no designated grantor. Trustees of the public trust are public officials, judges, attorneys, any government agents of any kind. Beneficiaries, debtors, of the public trust are the people. These guys.
Beneficiary, what's the benefit?
you get the benefit of what the corporations are doing for you.
Okay, corporation meaning the government.
Yeah.
Got it.
Trustees, the public trust is the government. That's jurisdiction B, right? Jurisdiction B down here, jurisdiction A up here. And notice how it's a mere reflection of what's going on up here.
Yeah.
Okay? So, who controls a trust?
The trustee.
Trustee. Who determines the duties of the trustee?
The maker.
The maker, the grantor. Okay? So, if the grantor creates the trust, trustee controls the trust. Okay, so this guy here was born into the world, and the law form that we're all operating under is known as admiralty. Is everyone familiar with that term? Admiralty, maritime law. The reason we're in admiralty is because admiralty has grace and mercy. It's the superior law form. Okay? Common law is execution on the law. Okay? If you go back to the Bible, in Genesis, actually, they talk about, or God gives Adam and Eve in the non-commercial zone, he gives them the law, which is everything is yours. There's no commercial transactions here. There is no payment. You take what you take. You give what you give. And, yeah.
When you listed the 5 law forms to start out with, you didn't list admiralty on there? So where
Admiralty falls into, it can be commercial law, and it could be common law. Because currently the common law is admiralty. Okay? Admiralty is the law of vessels. And back in the 1600s, they got all existential on the law, and they said, yeah, we're all vessels in the sea of space. Okay, so Lord Mansfield in 1753 decided, yep, admiralty is now part of the common law. Okay, so in order for you to operate in admiralty, they need to give you a berth, a B-E-R-T-H, a berth in admiralty. And that berth, your mom filled out an application for a birth certificate. Application had your little feet print on it and everything. So what she does is she fills out the application, and they approve you. Yeah?
Is that birth application, is birth spelled B-R-T-H on that?
It's spelled B-I-R-T-H,
Okay.
but it's the same meaning. It's just like a birth. What's that?
The birth in admiralty law is spelled with an I?
Yeah. No. Just on the birth certificate.
Got it.
Okay. If they spelled it with an E, they'd be giving away what's going on.
Right.
Yeah.
Right.
So you get a birth certificate. Birth certificate is your foreign situs trust. Okay, it's what gives you the ability to operate with all the other vessels. If your vessel doesn't have a berth in commerce, then your vessel can't interact with other vessels. Okay, but this vessel is foreign to jurisdiction B, or the democracy. Okay? So, they created the birth certificate, and then corporation came along. This corporation, which was established around 1859, known as the Federal Corporation. And the Federal Corporation said, hey, we've got all these benefits and privileges for our members. We call those members U.S. citizens. Okay? They offered you benefits and privileges. These benefits and privileges came across came in the form of your Social Security or your social insurance contract. Okay? When you signed on for social insurance, you said, yeah, I'll take your benefits and privileges. And created another trust. This trust we'll call a cesticate trust, an implied trust. Okay? And this implied trust now gives you benefits and privileges. Not only are you able to interact with all the other trusts out here, but you get the benefits and privileges of being a debtor in the United States, which is you don't have to pay. There is no gold anyways. There is no real money for you to pay for anything. But the benefits and privileges are you get to operate in commerce, you get to go to jail to pay your debts and things like that. Okay? In the common law, there is no debtor's prison. Okay? But in commerce and admiralty, there's debtor's prison. And so your benefit is to serve jail time to pay your debt. That's one of the benefits of working in commerce. If we were in common law, okay, not in commercial law, what would the rights of the creditor be if you owed me a debt? I could force you to work off that debt with me. That's how common law works. It's execution on the law. Okay? Actually, let me get back to the story I was telling about the Adam and Eve in the Garden of Eden. Garden of Eden was a non-commercial zone. Okay? There was no money. But as soon as Adam and Eve broke the law, and God told them beforehand, if you touch the fruit, you will surely die. He gave, here's the restriction, here's the punishment. Okay. Did he kill Adam and Eve when they touched the fruit? No. He switched law forms on them. He switched to admiralty. He switched to grace and mercy. He's like, okay, I know I said I was going to kill you, but instead, we're going to go into a commercial law form. We're no longer in law of the land. Okay, and in this commercial law form, you get to discharge your debts. Meaning, I get to put my debts off into the future. Okay? So he basically said, okay, here's the they came to him with, what did they put on? When they, after fig leaves. So they said, okay, we're going to pay with fig leaves. God says, no, no, no. Creditor determines the money.
Was Adam and Eve operating in bankruptcy at that time?
Not yet. They were entering bankruptcy at this time. Okay? So Adam and Eve, because basically if you don't pay your debt, you're in bankruptcy. Okay? And Adam and Eve were given the ability to discharge. Now, discharge does not eliminate the debt. It puts it off into some future time. Okay? So the money that the creditor chose, God, he said, no, 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 the money is going to be the blood of animals. Okay? Sacrifice of animals, that's going to be the money. That's how you're going to pay your debt to me. Okay? So he gave them the ability to discharge. Okay? So they move into the commercial zone. And from that point forward, we've been operating under, or from that point until Jesus, they operated under what we would call discharge. Okay? Jesus came up with a new concept, or at least those who wrote the religion based on him did. And this new concept was prepayment. You ever heard Jesus died for your sins? Sins are debts. He prepaid your debt. So we're not putting the debt off into the future now. We're prepaying it. We're saying the debt's already paid. Okay? So this new system of law, we have redemption, right? We talk about redemption in the New Testament. Well, this is commercial redemption. And that's what they were giving you with this New Testament, this new contract. Okay? We're no longer operating under execution of the law. We're going to operate in a commercial zone where there's prepayment of all debts. Okay? So in 1933, remember I said they can't take anything without giving you something of equal or greater value? So what they gave you was the ability to set off your debts. Okay? You no longer, the debts are now prepaid. Okay? Everything in your society is prepaid. Where does money come from? Does anyone know?
Printing press.
Whatever an individual and another person contract or saves money, or
Close.
Energy. It's a trade.
Your signature. Your signature creates all the money. If there aren't, since all corporations are dead things, they're all vessels with all capital names. Everyone knows that, right? Anything with a name in all capital letters is a vessel. Okay. All corporations are vessels. They're dead. They don't have the ability to create money. Only you do. Okay? So when you sign a promissory note for your house, you're creating money. Those funds actually go straight to an escrow account. Okay? You actually paid for the house. Now, the bank in their infinite greed don't tell you that. But if you knew as a creditor how to interact with the IRS, you could discharge that debt. Because, yeah,
Do you offset it or discharge it?
you discharge it. You can set it off, but there's no debt. See, you paid for it. They tricked you into a new contract, which basically says, yeah, I'm going to pay you money even though I just paid you all the money. And the wisdom in this system is that if you're a debtor, you're going to have to work harder and harder, right? Now, the system is a balance, okay? If everyone was responsible and everyone was a creditor, there would be no money. We would all walk around and just sign our names to pay for things. But the fact is they're debtors and people who refuse to take responsibility. And in that system, you can't tell, okay, you debtors, this is how things work, and then we come over here and say, okay, creditors, this is really how things work. Okay, we just have to assume you're all debtors. Okay, and if you're all debtors, then you're under the slave system. You're controlled. Title to your body is being held. Okay, and in the world of debtors, we've put a financial intermediary in place, and that's the banks. The banks block you from your credit. You sign it and you create it. If you endorse a check, you created the funds for that check. You've authorized the bank to create funds out of nothing. Okay?
That's why I'll never deposit without a signature.
Yeah, you couldn't deposit anything if there wasn't a signature on there. Okay? Except for a money order. But a money order is actually backed by gold. I don't know if you guys knew that. Without you, the bank couldn't create money. The Federal Reserve can't create money. In a deposit situation, you're the grantor. They take on the role as trustee. You're a trustee because when you sign a check, you're an authorized representative of the bank. You're working for the bank whenever you sign your check. The post office actually operates in jurisdiction A and B. The post office is not part of the democracy, but the Postal Service is. People who use the UCC1 financing statement is just a public notice. If you don't have a claim from jurisdiction A, it's pointless for you to do a UCC1 filing. Okay, and those of you who aren't familiar with UCC1 financing statement is a way for a foreign creditor to perfect or to put into the public record their security interest. So, for instance, I have a security interest on a piece of real property. I will go down to the county because it's the county records that are involved with real property, and I will file a UCC1 financing statement that lists the real property as collateral, has me as the creditor, and whoever the grantor or the trustor or the owner-debtor as the debtor on the UCC1 financing statement. So that's the three essential elements on a financing statement: creditor or secured party, debtor, and collateral. And it's just a public notice. It's your claim that has all the weight, but your claim you never put into public. You need to learn how to perfect a claim. That is the most important part of operating in commerce. Once you know how to get a claim, you have unlimited power in this commercial system. You really can do whatever you want as long as it's, not hurting or damaging anyone else. A Federal Reserve note is remember, we're an admiralty. It's a negotiable instrument, okay? And it's actually an improper negotiable instrument. If you go through the negotiable instrument law, it's not sufficient to qualify as a negotiable instrument. But remember over here, they said, hey, if you want to be a member of this, you get special benefits and privileges. One of those benefits and privileges is the benefit and privilege of trading that worthless paper. Okay, you get to carry this worthless paper around and you get to give it to other people even though it's not a proper negotiable instrument. That's why in jurisdiction B, they can't acknowledge jurisdiction A. If jurisdiction B recognized jurisdiction A, all judges, attorneys, they'd have to be executed. No, it's no. No, they're the watchmen's on the wall. They're here to help you. Believe it or not, they're here to help you. So they can't acknowledge jurisdiction A.
So we're all operating in fraud?
In some sense, but really, it's just uninformed. If you understand what you're doing, it's not really a fraud. They've made you believe that it's a republic and that the Constitution is what our laws are based on, but that's not the case. It's commercial law. Creditors make the rules. So when you walk into a court, the only thing the judge is trying to determine, are you a creditor or are you a debtor? If you're a creditor, he's going to find in your favor. If you're a debtor, he's not going to find in your favor.
What makes a creditor a debtor?
What makes a creditor a debtor? He determines by your actions, not by your words. You can't go, oh, sir, I'm a creditor. He's like, oh, you're a creditor? Perfect. You know, he's not going to find in your favor by what you say. He's going to find in your favor by how you act. A creditor is always at peace, is always bringing a solution.
Not arguing.
Not arguing. Okay, if you're arguing, you're in commercial warfare. You're a debtor. Okay, so it's all in your actions. Everything you do, the way you speak, you'll start to notice, and this is a heavy concept that we go into a lot on our weekly calls, and we'll do in this class, is being a creditor is a state of mind. And once you really get being a creditor, you'll have no fear. How many of you are familiar with the 213 amendments of the Constitution?
What?
The 213 amendments. Okay, there's a couple people. Okay, the first 13th amendment was no titles of nobility. Okay?
Right.
Titles of nobility are like esquire. Okay, they said no, attorneys cannot be part of this country or this government. Okay? The second 13th amendment got rid of slavery, involuntary servitude. And then they created a new government, which was the federal corporation, the democracy. And in that democracy, because it's a military democracy, if you look in the old Army manual from before 1933, a democracy was actually a very bad thing. It's a military-controlled government. Are there titles of nobility in the military? Yeah. The whole system's on rank, right? Okay? So they created a new class or a new title of nobility known as a U.S. citizen. A U.S. citizen is a title of nobility. And at that point, it was also okay for esquires to be part of the government. Okay? So we're operating, or the democracy is operating under the laws of tribunal, military tribunal. Okay, that's basically what's going on in the democracy. That's why it doesn't seem to work how you think it should work. When you go into court, you're guilty. By showing up, you're guilty. It's the hearing in the court is your first appeal. Okay? The moment you got charged, you were guilty. Have any of you ever seen that movie with Tom Cruise and You Can't Handle the Truth? You know, Few Good Men, that's it, Few Good Men. And remember, they made a big deal out of Tom Cruise even accusing, even asking the question if he had done this act, right? Because the act of an officer accusing is the judgment. Okay, so when an officer writes you a ticket, that's the judgment. That was your first hearing. When you show up to court, it's your first appeal. And you have a right to a hearing and to appeals. That's all you have a right to. Your first appeal is the court hearing. Then you could take it to an appellate court if it doesn't go your way. And then after that, they don't have to hear it. Okay? So basically, the democracy is run like a military tribunal. Creditors operate outside of the democracy. You cannot be a creditor inside the democracy, even though your straw man is your creditor in the democracy. Everything's backwards and mirror image in the democracy. So your U.S. citizen, that thing that from jurisdiction A, it's a debtor. But in jurisdiction B, the straw man is the creditor. And the living man is the debtor. Okay?
So we're the straw man?
What's that?
Are we the straw man?
The straw man is a trust. It's a stack of papers. Realistically, if I call you by your name, that's not you. That's an identity, a legal identity. Okay? So no matter how you write your name or you spell your name, all uppercase, lowercase, all lowercase, hieroglyphics, however you want to write your name, it's fictional. You are not the name, you are not the title. The title is a fiction. Okay, we haven't really talked that much about fiction, but everything in commerce is fictional. Okay? Because everything interacting in commerce is dead or a vessel. Okay? So there is no positive law. Everything is through volunteering and agreement. And that's the basis of the control that you are subject to. You're only subject if you volunteer to be subject. Realistically, it should be a bailor or bailee. Should be your UCC filing. If you're filing a UCC financing statement on yourself, you would want the straw man as the creditor. Because the straw man is the creditor, right? Isn't it the straw man's account that generates all the money? I mean, realistically, you can't interact with the democracy or jurisdiction B. Only the straw man can. So you're really a trustee for the straw man. The straw man is a trust, and you're the trustee. And I don't know how many of you are familiar with like the patriot movements that are out there, and there's people who go into court and, I'm not the straw man. That's not how I write my name, all uppercase. The judge isn't stupid. He knows you're not the straw man. But guess who's responsible? The trustee. And you are the trustee. And your body, because they hold the title on it, is going to be surety for that trust. So when they haul in the vessel, remember this is admiralty law, first thing you do is arrest the vessel, bring it into court, attach it as a surety to the charges, and then make a decision. Are you a debtor or are you a creditor? And we'll go from there. If you're the creditor, you're gonna put something up that's going to release the vessel. You're going to bond it, right? If you put up a bond, there's no need for the body to be a surety. The bond covers that. Okay? That's really what they're doing when they're holding the body. The body is the bond. It's the surety for the charge. And remember, the charge is fact. The fact that there's a charge right there means you are guilty. Does anyone actually know what you're doing when you plead guilty? Or where the word guilty comes from? Gilded. It's from the Old English for gilded, which means to pay. Okay? So when you say I'm not guilty, no, first they ask you, do you understand the charges? They're not asking like, do you understand English? Hello, can you understand what I'm saying? That's not what they're asking you. What they're asking you is, will you stand under these charges? Are you going to be the surety for these charges? Yes, sir, I understand these charges. Okay, how do you plead? Not guilty. You just said you were going to be responsible, now you're saying you're not going to pay. You're in contempt. Immediately, you're in contempt. Dishonor. You're not acting as a creditor. You're not bringing a solution. You're actually delaying the judge from getting done what he needs to get done.
So then what would be the response?
Yeah, I understand. I'll stand under these.
Just take care of it.
Yeah.
Settle it.
And I plead guilty to the facts.
See, I think...
See, people get in their head that pleading guilty is something bad.
Right, that's what I was just...
You're saying, I'm paying. I'm going to plead guilty to the facts. I'm going to waive any benefits and privileges of prison. And I'm going to effect payment immediately. Because now I'm in honor. And they can't put a person in honor in jail. You've honored the agreement. You've volunteered to be surety, and as surety, you're bringing a bond, or you're going to underwrite those charges. Surety means that's the source of payment. The surety is the guarantor is the surety. The surety is the guarantor. So just like when you co-sign for little Billy to get his car, you're the surety. You're the guarantor on the loan, even though little Billy's credit paid for it up front. You will become experts in commerce.
Right.
And by becoming an expert in commerce, you can be a creditor, and creditors control. So if the world isn't exactly like how you think it should be, well, then now it's your opportunity to take responsibility, step up, and change it. That's what I'm bringing to you. The ability for us to stand for our community and to make it into the community that we want, because we have that power. We've been irresponsible. The whole world. Most of the people in the world are completely irresponsible. And if we step up and take responsibility, you won't no longer be crying to jurisdiction B for them to fix all your problems. And just like everyone was so jazzed about bringing Obama in, well, everyone was jazzed about bringing FDR in too. Okay? And they're no different. Obama's going to do the same thing. He's like, okay, you think government's the solution? All righty, here we go. More restrictions, because you're going to be paying. And if you're paying, we need to figure out a way to bring that revenue in. You want us to fix it. If you're going to jurisdiction B, the public, and you're saying, fix our problems, they're like, okay, we're going to give you some more benefits, but we're going to restrict you. We're going to control even more aspects of your life now. You think they were controlling a lot up until now. Wait until this new level of bankruptcy. Because now, at 1929, 7 years later, 1999, second witness came around in 2008 with the financial collapse of 2008. And now, does anyone remember when the first vote on the bailout? Bush came to Congress and said, you know, are the people going to foot the bill? And through the representatives, over 20-1, people said, no way, we will not bail out Wall Street. We refuse to take responsibility. We're debtors. 3 days later, he goes back before Congress and says, well, will the corporation take responsibility? They're like, yeah. Corporation will take responsibility. No problem. It's already secured by the international bankers anyways. But the Chinese wanted to make sure they can, because now the Chinese hold a huge security interest in the United States. They wanted to be able to guarantee that security, so they wrote in their own little clause there that now the Chinese military can come into the United States to protect their property, to protect their security interest.
What's going to happen when they foreclose?
Well, they won't foreclose, probably, unless we get belligerent. You know, it's when a nation gets belligerent that you send a military in, like what we did with Iraq. The whole Iraq war is purely commercial. If I can't protect my security interests in the country of Iraq, well then they're dishonoring the international commercial system. And if they're dishonoring the international commercial system, they're a wild card that we can't have. So we send in the military. We set up, what was the one thing they were trying to establish? Constitution, right? Wanted them to be a democracy. Because as soon as they have a constitution, the debt is guaranteed. The people are guaranteeing the debt by signing the Constitution. So that's what they want. And realistically, that's what the international bankers, the international controllers, they are bending over backwards to give you the best system possible. Believe it. It's all completely in alignment with universal law. That's why I'm not particularly religious. I don't actually belong to any religion or anything. But the Bible has multiple layers to it. One of those layers is a commercial layer. It is the entire commercial system laid out. And it's written in such a way that it's in alignment with the universal laws. You know, whether you believe in the Bible or not, I'm sure you've heard of what you put out there comes back. And when you do put something bad out there, it comes back 10 times. Okay? All those numbers in the Bible have a very specific meaning and a commercial corollary, where we get all our commercial timelines. The seven years for bankruptcy, the 70 years for an international bankruptcy, 10 days for a commercial process, 3 days for a commercial process. All those numbers are in the Bible. And it's your commercial system. And as long as they're doing it by that system, they follow the Bible to the T. They're the sons of Cain. You guys remember the story of Cain and Abel? Okay? We had our very first tax protester, Cain. He pays his taxes with vegetables. God says, that ain't money, man. I told you. Money is the blood of an animal. Cain says, I'm a farmer. And actually, let me go back in Genesis a few chapters. God went to Cain and said, will you follow my law? What did Cain say? No, I ain't going to follow your law. He went to Abel. Will you follow my law? Yes, I will follow it to a T. I will follow your law. Did Abel follow the law? No. Cain follows the law to the T. And the sons of Cain are the ones who have been put in charge of you. The sons of Cain you don't see the religious system in your courts or in your system of commerce. They say, we don't follow God's law. And then they follow it to a T. Yeah, but they follow that law to a T. They follow that commercial law that's been set forth in the Bible. And when Cain, the first tax protester, refused to pay with blood, or he didn't refuse, actually. He got approached by God. God said, no, this isn't proper payment. This is like when your parents came with fig leaves and tried to pay. We're not going to accept vegetables. Cain says, okay, so you want blood. Here you go. My brother. Right? Kills his brother. He says, that's what you said. You wanted blood. So God going, okay, well, he didn't exactly dishonor, but he's using stolen funds to pay his debt, right? So as a creditor, am I supposed to just take your stolen funds as payment? No. So here, we're back. Now he takes them into admiralty, gives them some mercy and some grace, and says, we're going to put off your debt. I'm not going to kill you now. And Cain said, well, yeah, that's all good and fine, but what about Abel's family? They're going to be pissed. And they're going to be after me. And God says, no, they won't. Because if they do, I'm going to return the retribution on them 10 times. So the correlation I'm making there is that the sons of Cain reject the law of God but follow it to a T. Sons of God say they're going to follow God's law and then don't. They're in dishonor. Sons of Cain know that it's about being in honor. If everyone was truly being a creditor, everything would be working.
Yeah.
Right? Because we wouldn't even need the Federal Reserve notes anymore. We wouldn't even need banks. Because we would all be giving. If everyone's giving, there's abundance and more than enough to go around. The fact is, we're not all giving. We're all living in some kind of limited state of mind that we're not coming from abundance. If we were coming from abundance, then we would take responsibility for our communities. We wouldn't say, please, government, make my community what I want it to be. Please, Mr. Police Officer, protect me. Please, Mr. Fireman, put out my fires. The fact is, we're not acting that way. And in order for the system to work, if there's a bunch of debtors, you need to keep the debtors in line. You need to keep the irresponsible people from completely destroying the system.
I guess what I'm asking is, if we become creditors, do you see any repercussions from the B side on creditors? I mean, what's the,
No,
when it
you
comes down to
control it.
brass tacks,
You control the B side. Who's, if you take all the people out of the corporations, what are the corporations going to do? Yeah. What can they do without people? Right? And if we're all loving our brother, honoring our brother, whether our brother is a policeman, whether our brother is an FBI agent, whether he's an IRS agent, whether he's a judge, whether he's an attorney, if we're honoring, what, do we need the corporation anymore? Remember, back in Genesis, where did we start out? Commercial-free zone. Walls protected by angels. Fact is, you're not ready for a commercial-free zone. That's the utopia everyone thinks they want. But greed puts you into the commercial zone. And as long as we're operating in the commercial zone, you're going to go by the rules of the commercial zone. Now, stepping up and being a creditor means this isn't a technology to make you above the law, although you are above their law. But realistically, to be a creditor, you need to be in honor with everyone. And if you're in honor and respecting and not coming from greed, there's no reason for them to touch you. You're making everything possible. You're the source. In law of the land, there's no such thing as insurance. In law of the land, there is no such thing as negotiable instruments. The fact that you're using negotiable instruments, checks, credit cards, Federal Reserve notes, you're demonstrating to them that you know you're an admiralty. And you have social insurance. See, there was no such thing as insurance until law of the sea, admiralty. And basically the reason why admiralty came to be was, okay, we're going to, send this ship off and I'm funding it, but there's no guarantee that this ship will ever come back. It could sink. The captain and his crew could just make off somewhere, some island in the middle of the Pacific. We'll never see him again. So we have to be able to insure the vessel. And then negotiable instruments in international banking. We needed to be able to we didn't want to have to carry our gold with us everywhere we went to purchase something. Negotiable instruments are law of the sea. So you've been using it, and it's been being used. And it's not a bad thing. Like I said, it has grace and mercy. Law of the land doesn't. You don't want them executing on the law, believe me. You do not want that.
Can you talk about dishonor and honor?
Yes. Okay, everything in commerce comes from offers and acceptances. Okay? Let's go back to the traffic ticket. Cop pulls you over, writes you a ticket. That's an offer. Okay? Now, there's 3 paths I guess you could take. You can accept it. You can refuse it. Or you can do nothing. But maxim of law, doing nothing is dishonor. Okay? So, accepting and paying is the only way to be honorable with any offer. Anything else is a dishonor. Even a conditional acceptance in most cases is a dishonor. Okay? So, I mean, we could take any situation. Let's say you've got felony charges against you in court, which could lead to jail time. Okay? The charge is the offer. And the judge, in his private folder, not the public record, but the private record that's held in judges' chambers, has the charging instrument. It's a negotiable instrument with someone's signature on it, charging you. It's actually, if it's a traffic case, it's the ticket. Remember, the cop gave you a copy. He didn't give you the original. He gave you a copy. The original is the charging instrument. That is in the judge's folder. Okay? Now, do you understand the charges? Yes, I understand the charges. I will be surety for this. How do you plead? How are you going to pay? I'm going to pay. Gilded. Okay? If I do anything else, I'm in dishonor. Okay? A creditor is always in honor with all of his transactions. If you say something, you do it. A creditor isn't going to charge his brother. Okay? So remember we were talking about offer and acceptance and being in honor. If you charge your brother, then you're in commercial warfare. Let them charge you all day long. Jesus said, turn the other cheek. Let them charge you and pay it. They've given you this great thing. When they took away your right to property, they gave you something so much more valuable, which was the ability to discharge and to set off with your signature. A controversy is created when you argue the facts. Okay? As a creditor, you will learn to establish the facts outside of jurisdiction B. See, creditors operate over in jurisdiction A. And in jurisdiction A, when you've perfected your claim, you have the facts. Okay? So you never go into jurisdiction B with an argument. If you go into jurisdiction B with an argument or create a controversy, you're in dishonor. But if you bring your private or foreign judgment from jurisdiction A and bring it into B and learn how to get it recognized in B, there's no facts in dispute. Your remedy is pay it.
So then what are our options to use for payment?
That will be
That will get into in details. Bonding, you'll learn how to use negotiable instruments. You'll learn how to make the IRS your best friend. Because the IRS will do all the work for you if you fill out the right forms.
And how to bypass the banks. And
Yeah.
you're saying that they're just serving as an
Yeah,
intermediary.
exactly. Choose a new intermediary.
Exactly.
My intermediary is the Secretary of Treasury. If you know what you're doing in A, nobody's going to want to mess with you. Nobody's going to want to mess with you because everyone in public, all public agents, judges, attorneys, they're all bonded. Okay? If I perfect a claim over here and attach it to their bond over here and liquidate, they're not a public agent anymore. They will not be insured or bonded anymore. And they can't serve their role if they don't have their bond. One of your benefits and privileges in jurisdiction B is that you operate under what's known as limited liability. Okay, all corporations, that's the reason we have corporations, operate under limited liability. Okay? Limited liability means you're not fully liable. Okay? Somebody else is going to pay your debt. Or they're going to do the work for you. Okay? Full commercial liability means I am completely liable. I am not standing on the benefits and privileges of some third party, agency, government, corporation, or anything of the like. I'm standing in my own right, completely liable. You can only be fully liable in jurisdiction A. Jurisdiction B, everything is limited liability. That's why the judge is bonded. If he wasn't bonded, I could drag him out of the court myself and hang him under my own system of law. But he's operating under the benefit and privilege of being in limited liability. So really, I can't touch him. I can only touch his bond. We talked about legal title and equitable title, right? Okay. In commerce, let's say I walk into a store, okay? Actually, maybe we should go into the prepaid account before we go into title. Let's do that. Or this kind of works together. If I go into a store and I take Federal Reserve notes out of my pocket and a can of soup from the shelf, and I put the can of soup to give it to the clerk, give them my funds. What do they give me in return?
Receipt.
A receipt. Receipt is your document of title. Okay? You have title to that can of beans now, or soup, whatever it was. Okay? So you have title to the can of soup. If the can of soup is damaged and you want to take it back to get your Federal Reserve notes back, what must you have? Receipt. The title. Okay? Document of title, or a certificate of title, is issued by the legal title holder. Okay? If I hold the legal title, I issue to the party with equitable interest, I'll issue them a certificate of title, which has their name on it showing they're the beneficiary. They're the owner-operator. Okay? But they do not have legal title. Okay? It's a trust. Title itself is a trust. Okay? If you have equitable title, you're the beneficiary of the trust. If you have legal title, you're the trustee. Okay? In a trust, you can be the grantor and the trustee. You can be the grantor and the beneficiary. But you can't be the grantor, the trustee, and the beneficiary. That ain't a trust. It's a one-man corporation. Okay? Unless there are multiple beneficiaries. Then you can be the grantor, the trustee, and one of the beneficiaries. Okay? So in the case of title, if you're the beneficiary because you've been issued the certificate of title, and you're the grantor, the one who put in the commercial energy, the trustee is the one who holds legal title. Now, does anyone know how to reverse a trust? If you are the grantor and the beneficiary, and the state is the trustee, they issue you a certificate of title, right? Let's go to the example of your car. Okay? You were the original grantor. You're the one who went to the state. You asked them. You said, here's my application. I want to register my car. They go, okay, we'll take legal title to your car. Here's your certificate of title showing you're the beneficiary. Okay? If I take that certificate and I change my mind, I say, you know what? I want to be the trustee. I want to have legal title. I want to be in charge of this trust. All I do is do the same thing they did to me. Accept it for value, return it to them, and now I've reversed the trust. I've certified it to them. See, initially they certified it to me because they're the legal title holder. But because I've got commercial energy, I can recertify it, give it to them, and now I've reversed the trust. Now they're the beneficial title holder, and I'm the trustee.
What am I returning?
The certificate.
Caution them not to actually go out and do that.
Yeah, no, I did it. I did earlier. Don't do anything unless you know what you're doing. Same with the title on a house. Title on a house is the grant deed, right? Grant deed is issued by who? Who certifies you a copy of the grant deed? County. County holds legal title on your property. Okay? You go down to the county and say, can I get a certified copy of that grant deed? They go, sure. $10, please. Here's your certified copy. I take that certified copy, recertify it back to them, say, yeah, I've just reversed it. I'm going to take legal title to this. Same thing with the driver's license. Driver's license is a trust. Same thing with any document of title that you get issued, the document of title gets issued to you, you reverse it by endorsing it and returning it.
Including a birth certificate.
Including the birth certificate. So the first step in being a creditor is take legal title to the body. Take legal title to the trust that was established on your behalf. Okay? That's the first thing you need to do. Nobody's a creditor unless you control the trust. You can't be a beneficiary out of control and be a creditor. Creditor has to maintain sovereignty. To maintain sovereignty, you've got to maintain control. Nobody's taken away your sovereignty. You voluntarily gave it up.
I don't quite understand how you gave, I don't understand how you gave up sovereignty because it happened when you were born and unable to write or understand.
Did your mom voluntarily fill out the application?
So my mother, as, what would you call that?
Fiduciary.
Oh, she's a fiduciary instead of a...
Trustee?
Okay. She did it for me.
Mm-hmm.
And that's still considered voluntary.
Yeah,
on
until
my
you're
part.
until you're 21, you're considered incompetent anyways.
Okay.
So
Sometimes after.
Yeah.
no, yeah, most people after too. But they basically, until you reach 21, when you're 21, you have the option of reversing all your trusts. Okay? You could do it before, but you'd have to, actually be responsible.
Why 21 and not 18?
18 is bondage. 18 is, notice how you can die for your country at 18, but you can't drink because you're not responsible. Remember, you can't do it for them, but you can take control of their trust as their parent. You can say, I'm going to take their birth certificate. I'm accepting it for value and returning it. I now am the trustee. Not the kid, I am. Not the state, I am. Okay?